Let's say you book a gym membership. You sign up online, tick the box that says, I agree to the terms and conditions, and boom, you're locked into a 12-month contract. A month later, they increase your fees. You complain, and they point to Clause 14b of the terms saying they can change prices whenever they want. You never read that clause. Does it matter? Welcome to the world of incorporation of terms in contract law. How terms become part of a binding agreement in the first place. There are three main ways terms can be incorporated: by signature, by notice, and by a course of dealing or custom. Then we have implied terms. These don't come from the contract document at all, but are read in by law, custom, or statute. Let's start with the most straightforward method: incorporation by signature. In the famous case of Lestrange versus Graucob, a woman signed a contract for a vending machine. She didn't read the small print, which excluded liability for faults. When the machine broke, she sued. The court said, nope. By signing, she was bound by the terms, even if she hadn't read them. So, if you sign something, you're generally taken to have agreed to all its terms, whether you read them or not. But what if you don't sign anything? That's where incorporation by notice comes in. If a party gives reasonable notice of the terms before or at the time of contract, those terms can still be binding. Take the case of Parker versus Southeastern Railway. A man left his luggage at a railway station. His ticket said, "See back," and on the back was a clause limiting liability. He hadn't read it. The court said it depends. Was reasonable notice of that clause given? In Thornton versus Shoe Lane Parking, Lord Denning was even stricter. A parking garage had an exclusion clause displayed after the customer took the ticket. Denning said it was too late. The contract was formed when the ticket machine spat out the ticket. You can't sneak in terms after the fact. So, timing matters. The more unusual or harsh a term is, the more explicit the notice has to be. If you want to rely on a clause saying, "We're not liable for anything," you can't bury it in small print. It needs to be bold, clear, and brought to the other person's attention. Then there's incorporation by a course of dealing, where two parties have done business repeatedly, and the same terms have been used each time. Even if they don't mention the terms in a new contract, a court might find the terms were implicitly agreed based on past behavior. For example, in McCutcheon versus David McBrain, a ferry company sometimes included terms limiting liability. Sometimes they didn't. When they didn't, and a car was lost, the court said the inconsistent practice wasn't enough. There wasn't a clear and regular course of dealing to justify implying the terms. Now let's talk about implied terms. These are different because they're not written or even mentioned by either party. Instead, they're implied by custom, trade usage, or statute. Custom or trade usage means that in certain industries, specific terms are so common that they're just understood. For example, in shipping or commodities trading, everyone knows how risk passes or how delays are handled, even if it's not spelled out. The courts can imply such terms if both parties operate in the same trade, and the usage is well established, reasonable, and certain. But be careful. The courts won't imply custom if it contradicts an express term or if it's too vague. The standard is high. Terms may also be implied by law, especially in certain types of contracts. A great example is in employment law, where terms like mutual trust and confidence, or the right to a safe working environment, are implied whether the contract says so or not. And finally, we have implied terms by statute. This is a major source of consumer protection. Under the Consumer Rights Act 2015, for example, terms are implied into contracts for goods and services. Like the goods must be of satisfactory quality, fit for purpose, and as described. These rights exist automatically and can't be excluded by contract. Similarly, the Sale of Goods Act 1979, for non-consumer sales, implies key terms into contracts for the sale of goods. So to recap, sign a contract? You're bound even if you didn't read it. Given notice of terms before the deal, those terms are likely in. Repeated dealings on the same terms? Courts may assume they're included. In certain trades, well-known customs can fill in the blanks. And finally, the law itself may step in to imply terms, especially for consumers and employees. Contract law doesn't just care about what's written down. It looks at what was agreed, how, and whether the law thinks it's fair to enforce the term. So next time someone says, it was in the T&Cs, ask, was it really part of the contract? Thank you for watching, and have a look around Dr. Yannis' channel for more.